Hi, Alysa. How are you?
Hi, good to see you.
Likewise. Hope you're doing well on this final crunch week before the holidays.
Oh my goodness, it's how many privacy policies can you churn out in 3 days? I don't know. We'll find out.
It's probably our last Privacy Huddle of the year, so might as well do a little recap of the hottest topics. Let's go ahead and dive in, starting with state-specific laws. Obviously, no shortage of those in 2024. 2025 looks like it will be the same. I would love to hear, just as these continue to amass, how are you advising businesses to approach these, whether as a whole, whether by specific state, any best practices or examples?
Sure. And obviously, it's going to really depend on the business and where they're starting from. I think if you go back to early days with just California, companies at that point were, I think a lot of them were just standing up privacy programs. And so their privacy policy might have had a California section or a California, Virginia, Colorado, Connecticut section. I think as we get so many more states, more and more are going into a state agnostic, right? You might have a US states and try to really harmonize as much as possible. You have to do individual call outs on a few points. Maybe that's an easier privacy policy to just manage and update over time. But you still have some who have a state by state approach, and that's not wrong, so long as they devil's in the details and making sure if you're calling out particular states, you don't want to leave out a state. That is effective, number one. And they are not all written the same, and the rights are not all the same on some of the key points. And so you just do want to make sure that you are tracking. I love myself a chart, but have your chart that you just keep updating over time so you've got a really good sense on what's right and what needs to be tweaked.
I'd love to call out the Oregon one specifically, right? That's a unique requirement with the third party list. What's the gotcha there? What should companies do to make sure they can handle that Oregon requirement?
Sure. And that one's a big issue because Oregon's been sending out letters to lots of companies. That law went into effect this past year over the summer. Oregonians have the right to request a list of specific third parties. So that is a right that needs to be identified in the privacy policy. You need to think about the privacy portal. So if somebody reads your privacy policy, goes to your privacy portal, how do they see that right and how can they exercise that right? And then company needs to provide that right. And the way that Oregon defines it, service providers are not included, affiliates are not included. It largely are the companies that are the recipients of sales and shares and targeted advertising, with maybe a few unique twists depending on the company and the individuals or companies it's sharing with.
Thanks, Alysa. Speaking of US states, another big issue recently has been data brokers and the future of where these data broker laws are going to go, from back with the California Delete Act to recent CPPA conversations. Alysa, what's the rumor mill saying for how current laws are going to go? And then are more states going to adopt things like this?
So data brokers continue to be in the spotlight. I agree that data brokers are going to continue to be highly regulated. That is not going to change in terms of easing up the requirements. California amended the definition of a data broker. That has not fully gone through the APA process to get filed by the Secretary of State. So it's not effective January 1. Catch your breath. Ideally, if it goes through the final steps, it should be effective April 1st. And the definition of what is a data broker got a lot broader. We've talked about this in prior huddles. So that's just a really key thing to look at in terms of the data you append, making sure you're not selling it. And then old information, 3 years or older, aging customer data, you also want to make sure you don't trigger the data broker definition that way. But the price for registration, if you are a data broker, went up significantly. And I know some have asked, well, is that price point? Are we going to see that across other states that have data broker registries? I don't think so. The cost was ostensibly to support the Delete Act, which is particular to California. CPPA has rulemaking, so there's an ongoing process to really have those types of changes, whereas you need a statutory change for most of the other states. While I think data brokers are going to be more regulated, I don't see just across the board increases to the cost of registration.
From a brand or reputation standpoint, what do you think is going to be the effect from maybe consumer opinions? If increased number of brands do have to classify themselves as data brokers, do you think that's going to have an impact on consumer habits or purchases?
Well, I think it's a nudge. So what I'm hearing from a lot of companies if they don't see their business as a data broker, then they're really evaluating the kinds of data that they are getting and what would be onward flows to not trigger the definition of a data broker. To your point, because the law changed, rather than say, okay, the law changed, it applies to me in this way, I do see behavioral changes if it's not going to materially be a negative impact to the business to make those changes.
Another major issue this past year has been wiretapping. No shortage of different lawsuits and variations across states. How do you think enforcement has shifted since this became an issue for brands? And what do you think we'll continue to see into the new year?
Yeah, so unfortunately, there's not a silver bullet here unless California and some of the other state legislatures amend their laws. We're going to see more of these. We're going to see more case decisions. We've seen some case law that has said you cannot use the wiretap laws of that state, like Massachusetts, to bring forth those claims. So we could see other court decisions that help give some clarity in particular states. I think it's about 90% of the volume of these is in California. We're going to wrestle with that. There's, maybe the legislature will amend California's law, but even it's a tough hill to climb, and I don't think we should count on it.
This wiretapping issue has been a major one on the catch side with our customers, and they're consistently coming to us for perspective and advice on how technology can help with this for that reason. What general advice are you giving to companies just for managing pixels, trackers, tags? How can they approach that in a better way to just guard as much as they can against these suits?
Well, one, nothing is risk-free, right? So the silver bullet to wiretap is having a consent defense. That's an opt-in, a clear demonstration of consent. Unlike state privacy laws, wiretap doesn't define what consent means, but at a minimum, you want something to point to say, have we captured consent? And so that's why we've seen a lot of banners pop up. Now, I will also say we've seen a lot of banners pop up with confusing language or language that doesn't really sync with what is happening on the page. So I think the most important risk mitigator is that you understand what is happening on your website and how that relates to the wiretapping claims so that you can make risk-based decisions on how you want to handle that, including if you want to use a banner, what's the right language, what's the right choice that you want to present. Sometimes even in your purchase flow or their user flow, you have additional opportunities to have some transparency and have somebody agree to the privacy policy with some call outs. So I think there's a variety of things you can do. It's not one easy plug and play, here you go, you don't need to worry about wiretap, but the case law is moving really fast. There's, like I said, a lot of different kinds of claims. So this is a good one to make friends with your outside counsel and have some good strategic discussions and also be able to relay that info to the business so that they know what they're getting into.
The next one on my list is, I think, a big issue, and I've heard you talk about it as a sleeper issue, this issue of sensitive data, specifically relating to teens and minors. This one is becoming confusing and very nuanced for brands with different ages out there of what is a child, what is a minor. What's the latest, and how are you advising your clients to tackle this one?
So maybe just to zoom out a little bit, I think for a long time, many were certainly familiar with COPPA and under 13 standards, and that wasn't an issue for a lot of businesses because under 13s are not their target audience. And then we had California change it to the under 16s. Well, now we have a number of states that redefine that to under 18. And that is a big deal because you have a lot more retailers and brands who in fact are targeting high school, teenage users, ad campaigns all around teenage users. And the issue is you need consent if you are dealing with a minor before you collect their personal information. And so you think about most homepages for most brands, it's not opt-in consent. And so there's not a really clear answer there. I don't see many companies wanting to raise their hand and go right to an age verification. And so these are conversations to have on how companies are going to approach. It's a good trade association conversation to have. We don't have standardization. So I think we're going to see a lot of creative options by companies over this next year.
That seems like a very challenging answer, to be honest. If I put myself in the brand shoes, I don't know quite what to do.
Right. Well, our teens, your target audience, and the law in some of these states is a little different. Some of the states have been challenged by courts because it's too loosey-goosey. It's my legal term standard in terms of is it likely to be used by teens, by minors? But I think that's step one, is really thinking about who is your audience? What's the low hanging fruit? Do you have ad campaigns that are all about targeting teens? I think that's very different than thinking about, I don't know, a wellness type product, and maybe there's a possibility that teens might be using. So I'd start with actual knowledge, but I would not finish my analysis at actual knowledge. I would think about some of these other factors.
Got it. Closely related to that is, of course, social media platforms and the data collection related to that. Speaking of the revenue side of the business being involved, couldn't be more pressure today for brands to be present on social media platforms. So, how should privacy leaders think about making sure their privacy policies are ready for that kind of presence?
Yeah, so I think this is another sleeper issue because I think people have the bolt on part of the privacy policy that's been around for a long time around cookie practices. And for some companies, that might be 3 paragraphs or more. And yet, if you think about the advertising practices with social media platforms, tags and pixels on page are one part of it, but a lot of it now is sharing identifiers in other ways via APIs. And I don't think a lot of privacy policies have been modernized to really speak about digital ad practices and data sharing in the way that a lot of companies are doing it. So I think taking a really good look at what your marketing practices are and the data sharing practices are, and then looking at your privacy policy in terms of who you share with and the categories of information that you are sharing with third parties, and really thinking, do we have consistency with what we're doing?
Well, let's end with one final question. Thank you for that whirlwind. Looking into 2025, your predictions for early in the year, what can we expect to see in the headlines?
Well, just think we've had a number of these states that have laws on the books and have been enforced maybe with a lighter touch over the last, I don't know, now several years. I think in the first half of the year, we're going to see an increased enforcement that's visible. I think we're going to see more sweeps from some of these new states that have new laws on the books just to say, hello, we're here. We saw that, you think about when CCPA was first enacted, we saw California do quite a bit of that. And so I do think we're going to see more of that. I keep looking at the state attorney general's websites that have privacy laws because we see FAQs start popping up on a lot more of those states. We're going to see rulemaking. So we want to definitely watch that and think about what's the risk on enforcement related to some of the new final rulemaking, including amended definitions to the CCPA. So just thinking through are all of the big issues: sensitive personal information, sale, interest-based advertising, shares. Those, we've already seen those enforced so much in the past. That's not going to change. So I really want to make sure that my house is in order, at least as to those top enforcement issues.
Thank you for all these nuggets of wisdom, and actually for all the nuggets of wisdom over 2024. It's been a pleasure having you on the Privacy Huddle, of course, and we will see you in the new year.
Sounds great. Happy New Year.